And Mr. Zapata's here. You're already under oath. Thank you, sir. Good morning, ma'am. Are you Maria Gutierrez?
Maria Gutierrez? Yes.
And Mr. Parker, will your client waive the formal reading of the indictment?
Sure, Your Honor.
Ms. Gutierrez, in cause number 25, DCCR 1120, you're charged with the state jail felony offense of theft of property from May 8th of 2025. And how do you plead to that charge?
No se declara. Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker and the translator?
Yes.
Do you fully understand those documents?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Gutierrez is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. And at this time, find you guilty of theft of property. Sentence you in accordance with your agreement to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you waived your right to appeal. I also handed you an admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. The admonishment is in Spanish. You should read it carefully. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, you should ask Mr. Parker.
Arma de juego como un tipo de arma o pistola. Sí, no puede tener usted.
All right. Thank you, ma'am. Good luck to you. You can go back with the bailiff.
Es todo, gracias.
Okay, so you're Dakota and Dorsey. All right, and was there any additional negotiations?
Just for the record, Judge, I've asked him without talking to Mr. Coleman if he would take the 20 years if it wasn't stacked. He indicated that he wouldn't. Mr. Coleman kind of implied that he may offer that, so I didn't know if you want to change that, but it hasn't really been an offer of that. But
all right, so Mr. Dorsey, it sounds like.
And just like that, we shift gears. New defendant, higher stakes. This isn't about guilt anymore. It's about strategy. When someone refuses a concurrent sentence offer while already facing 30 years, that tells you one thing. They believe the appeal might save them.
Set for trial. Mr. Dorsey, Mr. Parker has been appointed to you, and he's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him, and I can appoint a new attorney today who could begin preparation for trial a little quicker. Is that okay with you? All right, we'll get that done. Mr. Parker, you're released, and Mr. Dorsey, someone will be appointed today. They should be out to see you very soon to begin preparation for trial. And do y'all know how long the appeal has been pending? Does anyone, do y'all have any idea?
It's been a couple months at least.
Okay. It was out of the other court though, right?
Yes, ma'am.
Okay. All right. So if y'all get any information on that, if you'll just let me know, it'd be nice to have that potentially by the time we go to trial, but we'll see. All right. Thank you, sir. You can go back with the bailiff.
And I think that Rat Pipes hired on that David Greer.
Good morning. Are you Dakota Coon? And Mr. Lewis, will your client waive the formal reading of the motion?
He does, yeah.
Mr. Coon, in cause number 23, DCCR 0968, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation March 1st of 2024 for the lesser offense of attempted assault on a family member by impeding breath or circulation, state jail felony, and that was a 2-year deferred probation. Is that correct?
Sure.
And then count 1 alleges that you violated your probation. It alleges that you committed the new offense of possession of a controlled substance, May 12th of 2025 in Chambers County, Texas. And is that true or not true?
True.
Count 2 alleges that you violated your probation by possessing a drug, cocaine, at the time of that arrest on May 12th in Chambers County. Is that true or not true?
True.
Count 3 alleges that you failed to never become intoxicated in that you provided a urine sample April 30th of 2025 that tested positive for cocaine. Is that true or not true?
True.
Count 3 alleges that you provided a urine sample May 9th of 2025 that tested positive for cocaine. Is that true or not true?
True.
Count 5 alleges that you provided a urine sample May 21st of 2025 that tested positive for cocaine. Is that true or not true?
True. Judge, that's enough.
Sure, the state abandoned 6, 7, and 8. Did you enter your pleas of true to counts 1 through 5 freely and voluntarily? Okay, and did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Kuhn is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of attempted assault on a family member by impeding breath or circulation. Sentence you in accordance with your agreement. Sorry, my tablet just got to a term of
15 months.
15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You should read that written admonishment to see what devices qualify as a firearm or ammunition. Also, if you have any questions about how long that lasts or any of those laws, you can talk to Mr. Lewis. All right, good luck to you, sir. You can go back with the bailiff. I was going to try to shorten it. That didn't work.
Where facts meet emotion, justice finds its voice. To witness more real courtroom moments, subscribe to Law Nexus.